Our next case is People versus Lewis. This is a 15-minute mini oral argument on the application. Welcome, counsel. You may reserve some of that time, but we ask you to please keep track of your own time. And you have 2 minutes of a free fire zone, if you wish, and you can begin when you're ready.
All right, thank you. Good afternoon, and may it please the court. Jason Eggert from the State Appellate Defender Office on behalf of Mr. Lewis. I'll do the best to keep track of my time and reserve time, understanding that that might not be possible, and I'll accept the court's questions at any time. We're asking this court to grant leave to appeal and enter an opinion in order, concluding that the search warrant for Mr. Lewis's home failed to state probable cause, and second, that the officers who applied for this warrant should not receive the benefit of the good faith exception when the affidavit at issue here is devoid of facts connecting the home to the $20 alleged sale of cocaine that occurred approximately 4 to 5 miles from his house. This single hand-to-hand transaction is simply insufficient to say that his home was connected to this offense. Now, granting leave to appeal in this case, I think, would serve a couple important interests here. As first is, while this is a totality of the circumstances analysis in every case, as Gates makes clear, and it's a fact-intensive nature for these warrant issues, first, it would deter police misconduct in cases like this, where warrants are solely based on an officer's training and experience that evidence of a crime would be found in a home or a cell phone or something like that. Now, second, I think it provides critical guidance to both law enforcement and magistrates who issue these warrants that what's required of them. In my practice, I can say I see warrants that are basically identical to this one, where there's probable cause. They've crossed the first prong of the Gates analysis by saying, well, we have probable cause to believe a crime may have been committed here. And to move to the second part, there's a simple statement from an officer that my training experience as an officer tells me evidence of a crime will be found in a particular place, and a general laundry list of things that they may think they would find based on the type of offense, in this case, a drug trafficking offense. Now, this type of warrant is invalid. I think the case law, review the case law that was in the order from this court makes clear that this is a warrant that's deficient. Now, the question becomes related to good faith, I think, in this case. Now, I've identified at least, I think, 2 categories of cases that kind of are outlined from this Reed opinion that was part of the grant of how good faith exception plays out in the instance of drug trafficking. Now, those factors are completely absent here. So first, I think a large category of the cases that we deal with in the Reed case and just in federal circuit case law in general deal with an instance where there's either a large, some type of large drug operation potentially, or some evidence of an ongoing recent pattern of drug trafficking activity. Now, looking at this warrant, there's no evidence of that. We have a single hand-to-hand transaction. He may have a history of drug trafficking offenses, but the closest one in time is nearly a decade old. And the amount of narcotics we have involved in this case is allegedly a $20 sale of cocaine. Also missing is evidence that there was some type of drug trafficking that was larger in scale occurring based on even the arrest. There wasn't a large amount of money or cash in the car. There were no evidence of drugs found in the car. Second, we have this category of cases, I think, that deal with some minimal connection to the home, something short of probable cause. And I think an example of that would be the White case that was in this court's order. But another example, I think, is from the prosecutor's briefs and the prosecutor hearings of Michigan. And it's the Helton case that they cite. Now, That case, they found that there wasn't probable cause because the affidavit, sorry, I have like a little bit of a cough going on for some reason. So there's a tip from a source that wasn't verified in that case. And so they found that, well, there's this tip connecting this house to drug trafficking activity. It's not 100%. There's not this evidence in the affidavit that we know this to be a reliable source. So we're not going to find probable cause. But what we do have is evidence of good faith here. They've connected the home to this offense. And it's important to remember that we're dealing with the home. This is a first among equals when it comes to Fourth Amendment inquiries. And simply a statement from law enforcement that my training experience tells me that evidence of a crime would be found in a particular place based on my experience in general doesn't speak to the specific home at issue or the specific offense they're investigating. And I think
Can you, I'm curious and would like your opinion or thoughts on what role does an opinion from this court or other case law as far as, say we were to say there isn't sufficient probable cause, the sufficient nexus isn't established by an affidavit that looks like this. If we were to say that, what role does the fact that we've said that play in the good faith analysis? You know, I'm thinking, like, we know in the context of like qualified immunity, right, where you have case law and, you know, without that, any reasonable officer may not know that their conduct was constitutionally violative, right? So when you have the case law to do that, you can establish or not establish qualified immunity. Is that the same type of analysis as far as like, look at the Supreme Court has said an affidavit that says A, B, and C isn't enough. You can't have good faith. An officer can't in good faith rely on an affidavit that says A, B, and C. Or is it, I mean, it doesn't seem to be that same type of application. Do they map onto each other that way or no?
I don't think it's a type of qualified immunity analysis where you essentially have to have the case on all fours to say, well, the government here is not going to get the benefit of qualified immunity. I think the inquiry in every Fourth Amendment analysis like this is going to be based on the totality of circumstances. So there is, you know, a fact-specific inquiry for each case. But I think a lesson that can be taken from this case and passed on to law enforcement and magistrates is that if you are going to draft a warrant for a home, you need to at least explain a little bit, at least maybe include one fact, that this home was somehow involved. And that's absent here. And I think this training experience reliance is an important message. You can't just have a warrant that says, I have probable cause that a crime has been committed, and here I get to search the home because my training experience tells me
Well,
that
what about,
individuals.
I mean, that idea, like, and I get it, that if we say this isn't a sufficient warrant, but a magistrate issues a warrant anyway, the magistrate probably shouldn't have, right? If our case law says that's not sufficient. They do, and an officer then, I have a warrant issued by a magistrate. Like, and it's, I mean, I guess they just defy it?
Well,
Because the Supreme Court said that the magistrate never should have issued that in the first place?
well, I think that Leon directly contemplates the scenario where suppression is required and the officers don't get the benefit of good faith when the warrant itself is a bare bones affidavit, and I think that that's what we have. You can't just have a general assertion of a belief that I think I will find evidence at this house because people who commit drug offenses generally have that evidence in their house. That's not a fact connecting a home to a crime. That's just a general assertion, and I think that's very basic Fourth Amendment precedent. I think the Nathanson case speaks to that. You just can't have general assertions without fact. And I think requiring a police officer to include a fact isn't a hyper-technical requirement. And it's something where when you fail to state any facts at all before you get to invade a home and search a home, that's not an instance where you should get the benefit of the good faith exception. It falls into that category of cases referenced in Leon that was then adopted in Goldstein.
So can I ask you, is our decision in Goldston a problem for you, right? Like we have, and even if we agree with you that there must be some daylight between the standard that is, what is a sufficient nexus so as to establish probable cause, and what is the good faith standard, right? There has to be some daylight, otherwise it would be subsumed. So, but in Goldston, we said that the affidavit, maybe there wasn't probable cause, but it satisfied, the good faith. And, I mean, does Goldston stand in the way of us saying that there was, maybe it didn't, maybe there wasn't a sufficient nexus, but the good faith exception still applies?
So I don't think Goldston's a barrier at all. It adopts Leon, and we're relying on some of the rationale in Leon with regard to bare bones affidavits. I don't think it's a barrier. Of course, in any case, if it were a closer call, in this case, there may be a problem with establishing to get over the hurdle of the good faith exception. But this is a case where there's simply not a single fact connecting to this home. There was no surveillance of the home. There was no informant saying Mr. Lewis was selling drugs from his home. There was nothing observed in front of the home. There weren't even trash bowls, anything like you would see in the cases that fall short of probable cause that get the benefit of the good faith exception. There's just
Didn't the affidavit, or maybe we don't know necessarily, but isn't at least the implication that the affidavit in Goldston, if we said that wasn't bare bones, I mean, maybe we can disagree whether or not that's right or not, but if the affidavit in Goldston wasn't bare bones, why is this one?
Well, I think this one is because I think that I think in Goldston there was more of a development of what was going to occur and why the house would be connected than there is here. This is just a general statement saying good faith, that my training experience as an officer says evidence is generally in these homes, so I get to see it.
Goldston admittedly wasn't a drug crime, right? It was a false, whatever.
And there is, depending on offenses, it's part of the fact-intensive totality of circumstances.
There may be certain crimes that saying they do sort of lend themselves to the idea that the home might have relevant evidence.
It could be, there could be a potential for that, and it depend on what's actually involved in that case. But I think in this case, there is a very clear-cut message that can be sent, at least at a minimum, to drug trafficking offenses, which are a very common offense in our state, that you cannot, as an officer, just say, my training experience tells me that drugs or drug paraphernalia to be found in a house, and expect to be able to rely on that warrant and obtain a conviction.
Was there any indication in the record how close the house was to where the drug activity took place?
Yeah, well, based on the addresses in the warrant, yes, I think it's 4 to 5 miles from there. The record's very clear that it occurred. There was a believed to be a hand-to-hand transaction in this party store parking lot. He drove about a couple blocks away from the party store where he was pulled over, and it's about 4.5 miles.
Reed and White, those courts, of course, they just assumed for argument purposes that the warrant was insufficient and moved on to the good faith analysis, and that's what the Court of Appeals did here. But Reed cites another case, Rosario, that says one court, for example, listed other potentially relevant factors. And you mentioned one of them, whether the suspect was engaged in large-scale operations. Here we don't have that. Whether the affidavit was based on the conclusions of experienced officers regarding where evidence of a crime is likely to be found. Arguably we have that here. Whether the defendant's home was in the same general area of the drug activity. It sounds like we have that here. And whether the probable cause existed to arrest the defendant for drug crimes. We have that here. So it seems, and we have admittedly stale drug activity from a significant time ago. You have that here that probably isn't enough by itself, but that's not all you have in this case. I mean, in other words, it seems to me far from clear that this was not a valid warrant based on those authorities. What am I missing?
So I think I would dispute first that this is close when considering the fact that this is in Grand Rapids. It's a densely populated area, and 4 to 5 miles in a place like that is quite some distance, especially when there's major highways right adjacent to this area, to suggest that that would indicate.
Doesn't say that the case, as it's summarized by Reed, doesn't say same neighborhood or same block, it says same general area, right?
Yeah, it does say that, and I think that's taken from a quote from the case. But when looking at these cases, when they say that training experience is certainly a factor in considering whether there's probable cause and maybe whether an officer could rely on something in good faith. However, in the absence of facts connecting a home, it's not enough, and I think that the case law bears that out. Even some of the cases, I think ARD has some language in there that talks about how training experience is relevant, but the ARD case deals with the large-scale transaction. It wasn't premised on that training experience alone is enough, and there's not a single case that I think stands for that proposition cited in Reed or any other case in that opinion.
Obviously, it was a lot of factors, as Justice Viviano pointed out. I'm wondering, Justice Viviano alluded to the stale drug charges. Would it have made a difference if the drug charges were a year old?
I think when you're talking about staleness, I think something, even when you're looking at a warrant, there's examples of it being a month after something could have been in a home, and the officers then going a month later being potentially stale. So I think the closest in time is definitely a relevant factor as to whether there's a good faith belief that there's recent pattern, and I think maybe something a little closer would produce a different result.
Thank you.
Thank you.
Thank you.
Good afternoon. James Benison with the Kent County Prosecutor's Office, appearing on behalf of the people of the state of Michigan. I think the first thing we need to do to evaluate probable cause here is to stop thinking like lawyers, which I know is hard for us to do because it's what we're ingrained to, but the standard that the Supreme Court has laid out for us is that when reviewing a warrant for probable cause, it's got to be done by lay person analysis. Would a reasonable person hearing that a guy who's been convicted 3 times of dealing drugs is just seen dealing drugs again, is going to his home, which we all know it's his home, he's just sold it, he doesn't have any paraphernalia or drugs on him, and the expert says that they likely keep it at their home, they don't keep all of their stuff with them. Hey, is it reasonable to think you would find evidence of drugs or drug sales or drug records at the home? And by throwing in the fact of records, that's one of the important distinctions between this and some of the other cases like Brown, which simply asked to search for drugs, period. Business records are going to exist when you've got a business. And here you've got a guy who had an on-call delivery to a customer. Well, that's going to make a reasonable person think this is probable cause. But certainly at a bare minimum, and I don't know that this court needs to reach it because I do think that, as it's alluded to, the good faith exception here is clearly at play in that they presented everything. Goldston was way less than this. Goldston was, the guy was collecting funds for the 9/11 firefighters on the street and had a thing that they took from him, and a few days later they go to his house to see if he's got more police or fire paraphernalia, and do they have a belief that he'd been doing it more other places? No, they just saw him the one time. And this court said that that was sufficient to go into his home under the good faith exception. So with that background and history, I don't think that there is a reason to overturn the Court of Appeals decision here or to do anything other than deny the application for leave to appeal.
Do we know what the affidavit said in Goldston?
The case,
At least from the majority opinion?
I don't have the, obviously we don't have the affidavit in hand, but the majority opinion summarized it as, if I reviewed this, and I want to be careful.
No,
that I
and
don't-
I'm not trying to catch you up by any
Yes.
means. I'm curious of that too, of, it would seem, like, if the analysis of saying that even if there wasn't probable cause, good faith, but we're looking at this, I think everybody agrees that we look at this affidavit. Does it have a sufficient connection? Or sufficient nexus, and then we're looking at good faith, and what are the differing standards, and what is the daylight that's between them, why is there a meaningful difference? And then there's just a statement in Goldston that says the affidavit wasn't bare bones. So Goldstone really tell us much about anything.
I think if you compare what was described in Goldston as being in the affidavit and compare it to what was given here, there was far more here than what was laid out in the majority opinion in Goldston. Goldston was, he did this thing on the street, and now we want to get into his home. And here he did this thing on the street, he's heading back to his home. The nature of this is going to put more stuff in his home, all of the other things that were included in there. And I think-
Is it relevant that, like, here you have the guy who bought it from him bought it for $20 and the defendant was found with $80 on him? Like, of whether or not this is some, there are gonna be records of some drug operation going on?
Given that the affidavit described that for-profit dealers of this sort are likely not to have all of their product on them, and when he gets a call from a customer and has a base of operations, that's in the affidavit, that these type of dealers are going to have a base of operations from which they go. They're going to leave most of their stuff at a place where they think it's safe and go out. So the fact that there wasn't anything in his vehicle, I think, is actually strong evidence that, okay, this is not a user seller who, okay, I need another bit of money to help me with my next hit, so I'll share one with you so that I can go to my next, and I'll have paraphernalia in my car to show evidence of use. The lack of that here, I think, is indicative that this was a businessman engaging in a sale when a customer called him up.
Did the affidavit, correct me, and I don't recall, did the affidavit make that distinction that you're making now about the significance of the lack of drugs in the vehicle?
It does not, but I think that's an inference that the magistrate
He
could
says that
easily
there's a
make.
difference between users and traffickers, but then doesn't necessarily provide facts that say why this guy is more likely a trafficker than a user, particularly with that point that you're making. It's not in his vehicle, it must be somewhere else because he's a trafficker.
It does not lay out that conclusion for the magistrate. The magistrate is allowed to make that inference on his own.
What are we to make of the fact that the affidavit states he was on federal probation for possession with intent to deliver?
I think that the magistrate should be allowed to consider that because it was a 2009 case and he's still on supervised release 9 years later. It helps indicate that that was a significant drug offense, and I think that it indicates that there was a reason to indicate that his business is dealing drugs. He might not be very effective at it and that he's been caught now 4 times, but it shows that that's what he's made his career being, and I think the magistrate could consider that. I don't know that I think the staleness is usually in terms of if I'm a crack cocaine user and I found with 1 rock, I'm not likely to have it on me 3 weeks later because there's no probable cause that it wouldn't have disappeared. But if I have stolen a painting and put it in my house, maybe like the Thomas Crown movie, I put it back on the shelves of the museum, but it's most likely to be in my house because I took it for that purpose and it's not something I'm going to easily consume.
And how does this fact tie to the house, to the home?
What it does is it helps explain why the conclusion that Mr. Lewis was a seller of drugs as opposed to a user of drugs. And once you are a seller, you are in a business, and businesses have records, and there are things which go with that. And I
So
think
all sellers, they can
Always?
get to the homes?
No,
And
I think
11 years later?
The fact of the prior sale and the fact that he's continuing to do it, I think it's the totality of the circumstances. It's not simply that he had 1 prior conviction or that he had 3 prior convictions, but it's the fact that he had those convictions. They were all for drug sales, not for possession. That's what the magistrate, he may have had more, but the affidavit only says those 3. They're all for possession with intent to deliver or delivery. That helps you understand his history, and then you hear what he does in this case. That is one of the many factors that the magistrate is allowed to consider in determining probable cause.
And still on probation that many years later.
Correct, and still being monitored and has not been released from federal supervision, so he hasn't proven himself sufficiently.
Couldn't that cut the other way? He's been on probation and he hasn't had any other offense or delivery charge in that time period, and obviously he's being monitored, doesn't that count? Could it cut the other way?
It could, but
Yeah.
it's up to the magistrate to make that determination, and we're required to provide great deference to the magistrate's determination. So if the magistrate in this case found that helpful, and we never know exactly, a magistrate might review a warrant and go, that fact doesn't matter to me at all, We don't know that because we don't require them to detail why they found probable cause. They just say, yes, I have by signing it, or no, they haven't, and they turn it back over to the officer, which does happen.
Understanding this is a federal probation, but are we to make anything at all of the fact that courts have concluded that probationers have diminished privacy rights?
I did mention that in my brief, in a, I believe maybe even in a footnote of,
In an unsatisfying way.
well, and the problem
That's
is,
why I
there
asked
isn't
about
of record whether he had a requirement as a condition of his probation to allow them to go into his home, which is why I don't think he'd automatically get a new trial as the defense has requested, even if this court granted him all of the other relief, because it would have to go back, and if there was a determination that his federal probation required him to allow the police to enter his home, then this is an advisory opinion, and we've done nothing in terms of this case, because they still would have been allowed to go in, get the evidence, and present it at trial.
And my question is a little more subtle than that. The fact that courts have generally held that probationers have diminished privacy rights, and we know that this person's on probation, how does that weigh when it comes to considering the adequacy of this warrant and the affidavit supporting it?
I think that the magistrate is allowed to consider that in evaluating the propriety of the entry into the defendant's home. I think it is certainly one of the factors they can do. I think also important, and I mentioned this, not only is there the Darwich case, which I mentioned in my brief, there's also the Nunez case where, again, these are the Michigan cases, not the Sixth Circuit cases. And I apologize, I didn't catch it at the time when I was drafting my brief. It's a 2000 case out of the Court of Appeals that said reasonable inference that traffickers often keep evidence in their homes was a permissible consideration, and that's prior to Goldston, so that's prior to good faith. That was a determination that that was part of the analysis for probable cause existing in that case. So I think that when we have somebody on probation, we have this prior history, the magistrate is following state law. If we're expecting the police officers to follow the law, they would have followed the law in Michigan and would have relied on cases like Darwich and Nunez and Hellstrom, which deals with the child sexual abuse material example I used in my brief.
How does that work? Like, what is the, and it's sort of, I asked it of your opposing counsel, say we were to say that this affidavit is insufficient to establish probable cause to search the home, right? Not a sufficient nexus based on all of this. But maybe good faith applies. What happens the next time? What role would an opinion from us play in evaluating whether a subsequent police officer can establish good faith reliance on, say, it's an identical affidavit?
I think if this court issues an opinion on April 1st of 2023, or I don't mean that to be a
That's ambitious, but yes.
July 31st of 2023, and says this is going to be insufficient, then we'll be able to train police going forward. You can't do this way. You need to add in additional information, but it certainly shouldn't be applied retroactively because everybody's relying on Darwish and Nunez and the case law that exists up to this point. I'm not sure this court's precedent typically allows it to do that, because if you can decide it on a lesser standard of good faith, it's typically not what you do, but I do know you have the authority to do that and to say we're going to make a pronouncement moving forward. And once you've done that, then there is no more good faith basis to rely on something which has now been declared improper. I think that would have to be the
And
case.
us, arguably, and unless we opine on it, we don't provide that guidance
Correct.
to officers. Okay.
Again, in terms of the good faith, I think it's really hard to say that these officers should have known better. If we look at Reed and acknowledging that it's murky and foggy, they're not expected to be legal experts. If they'd looked at Lafayette's treatise, they would have seen one thing. If they looked at Brown, they may have seen something else. They go to the magistrate and say, you tell us if this is enough. And the magistrate's allowed to say no. They sometimes do. And either they go back and provide additional information to them, or they don't go into the home. With that background, there's no way I think you could possibly say that this doesn't survive good faith. But I think the deferential standard for probable cause, it still exists here, but I understand that this court probably granted, because at least some of you have questions about that, so, unless the court has other questions.
Thank you. The case will be submitted. No?
I'd like to ask you.
Oh, I'm sorry, you're not
I
done
just want to
yet.
ask you a question. I didn't ask you when you, I know, and I didn't ask you while you were up the prior time. And then I raised it with Appley about this whole question of the federal probation. I'm just offering you an opportunity to respond to my questioning and his response to it, if you care to. If you don't want to, that's fine too.
Of course, I'll take the opportunity, Justice Zara. So I don't think that that impacts the analysis. I think when there's a supervisory search, it's clear from the outset that the purpose of the search that's taking place is under the auspices of supervision. This was a very clear-cut example of officers pursuing a completely separate criminal investigation. They occurred very quickly. You have the alleged $20 sale, and about an hour later, they're in his house. And there's just no evidence to suggest that the purpose of the search was to supervise him.
But when the reviewing magistrate reads an affidavit and sees that there was a prior delivery charge in federal that resulted in probation, and that years later the probation is continuing, can they not take something from that, that perhaps this is someone who has a history of delivery and there may be evidence within the home?
So I don't, in this case, I don't think so. There's just too much of a gap of time between that offense. It's a decade-old conviction. Granted, there is supervision, but I don't think that's a fact that connects his home, particularly given the amount of time that's passed and the lack of evidence that there was any activity outside of this $20 sale from there.
Okay, thank you.
Yeah.
You know, I just ask a question? So if we were to adopt brother counsel's position, what would the impact be in cases of this nature? What would the overall effect be?
So I think if the prosecution's position is adopted, that the second inquiry that's required by Gates is whether there's probable cause to believe evidence of a crime is in the place or thing to be searched is meaningless. Officers can simply say, I've observed the crime, and my training experience as an officer, I've executed X amount of warrants over the years, and when I've executed a warrant for drug trafficking or fill in any other offense, I find evidence of that crime there, typically. So I should be able to search there because that's how it works.
So it would really make it so that there's limited to almost no requirements, right, as to the specificity of what it is that you're looking for and the basis to which you're going to find it.
That's my position. I think it would, a warrant like this without any facts connecting the home, which is the entire purpose
What
of
about,
the
what
search
about
warrant.
my questions? You're just ignoring those? The homes in the general area? He's picked up on the drug activity, he's arrested for that, and there is a third thing in here. And you have his drug history, his criminal history, which I think I agree with you. The fact that he's on probation doesn't really add much to the fact that he has these 3 priors, but what extends that to the present time is the fact that he was just arrested for drug delivery, right? That's what connects you to the past. It's not as though all you have here are stale convictions and an officer saying, well, I think you're going to find evidence at the house. We have some more here that you're just not acknowledging. If your position is that this wipes out everything now and all you need is an officer to say something's going to be at the house and they can go carte blanche, that's not really this case, is it?
So I do think it's that case. I think the cases that you look at where there's some proximity to home don't involve something where it's 4 to 5 miles away. They involve something where you're on the street, they've observed something, they watch you sell from the driveway, which is a very common fact pattern in the cases that were listed in Reed. So I don't think the proximity is a very persuasive factor. I think given the fact that his history is approximately a decade old, it impacts the significance of that. If we're talking about recent history, which is the line of cases when they're talking about good faith, is there an ongoing pattern of recent drug trafficking activity? A decade ago doesn't establish a recent pattern. You can't have 10 years and then one $20 sale and now we have a pattern. I think it's significant when we're looking at these types of cases that what's being sought to invade is the home. And that's the most important place when we're talking about the Fourth Amendment. And it takes more than just observing a crime in your belief that the evidence of that crime will be
No,
there without
get it.
supporting
I
facts.
don't know this is the strongest warrant I've ever seen. The point is that all of these different factors, sort of, when you add them into the mix, they're all, you know, they're all kind of faint, right? They're all sort of faint signals, but when you add them all into the mix, does it get to the probable cause, or at least within the good faith realm? That's what we're trying to determine today.
Yeah, and I would say, I don't think that they reach that level, given the particular facts of this case. There's just too long of a gap between that history. He's not really in the proximity of home where there's any
You got a
real
long-
fair inference
You
that.
got a long time on rebuttal for someone. who
Yeah.
didn't have that.
I have-
Thank you.
Thank you.
Yeah, thank you. The case will be submitted.
Well, I'm gonna ask,
Thank you.
I'm gonna ask one more question really quick.
Yeah.
I can't resist. So just to kind of go back to the essence prior to Justice Viana's questions is, the concern that we have to really get into in this situation is that if we were to not go with your position, what could ultimately happen is it really could weaken the warrant requirement, and it could have an impact on the level, nature, and specificity that is a requirement as it pertains to these materials.
You have 30 seconds to answer.
Okay, I agree with that position that it would weaken the warrant requirement. I don't think that a simple holding that this isn't probable cause would establish something for the next line of cases. It would be equally precedent that the officer in this circumstance would be able to rely in good faith on this warrant. And so I don't think a simple holding that this is not probable cause would be sufficient. And for those reasons, we would ask you to remand this case to the trial court for a new trial.
Thank you, Counsel.
Thank you both. Case will be submitted.